Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we were focusing on chapter 2, which is all about relevancy of facts. This is covered between section 5 to 55, and in this series, we were focusing on a mini series on opinions covered between section 45 to 51. Out of total 7 sections, we have already covered 5 sections, and in this video I am going to focus on section 50, which is all about opinion on relationship when relevant. I am going to explain the Bare Act provision, then I will easen it with the help of a beautiful chart, and finally we will also discuss illustrations as well as case laws. With that, it will be a comprehensive discussion on this particular topic, and I am taking to the first slide. Section 50 discusses on opinion on relationship when relevant. The Bare Act provision says when the court has to form an opinion. Just like any other section, the start of this particular section is also the same. Here, the court has to form an opinion related to what? As to the relationship of one person to another. The question here in front of the court is, what is the relationship between two individuals? In such case, the opinion expressed by conduct as to the existence of such relationship. See, here the opinion is expressed in a way of conduct, not by words or so. It is by way of expressing it by any kind of conduct. So the opinion expressed by conduct as to the existence of such relationship of any person who as a member of the family or otherwise. Now, who can make such opinion in the form of expressing by conduct? It may be a family member or any other person. Has special means of knowledge on the subject is a relevant fact. Only requirement here is such person who is making opinion by expressing by conduct has special means of knowledge on the subject. If that is happened, he may be a family member or may not be, his opinion is a relevant fact. But here there are few exceptions which is mentioned here, provided that such opinion shall not be sufficient to prove a marriage in proceedings under the Indian Divorce Act 1869. That is the first exception, where it says it is not sufficient to prove marriage in proceedings under the Indian Divorce Act 1869 or in the prosecutions under section 494, section 495, section 497 or section 498 of Indian Penal Code. Don't worry anything about these sections. I am going to explain all of them along with section 50 of Evidence Act in my next slide with a beautiful chart. Let's get into that particular slide. Let us now try understand section 50 with the help of this beautiful chart. Like any other sections which are discussing about opinions, here also the court is in such a situation where it has to form an opinion. And this time that opinion is related to the relationship between two individuals. Now court has to make an opinion that what is the relationship between X and Y. Now maybe X is available, Y is already dead, or Y is available and X is already dead, or maybe X and Y both are dead, or maybe X and Y both are available in front of the court. Now whatever may be the scenario, here the question in front of the court is, what is the relationship between X and Y? Now court has to make an opinion on that, but court doesn't have sufficient information. In such case, if any person, when I say any person, he may be the family member of X and Y or maybe any other person. Now if he or she confirms the relationship between X and Y on the basis of knowledge that he has on particular topic or subject, or he has expressed opinion by conduct and as to the existence of such relationship. Now all these three are very, very important. One, the person who is making opinion has the special knowledge on the subject. Two, he has expressed opinion by conduct. This will be clarified when I am explaining the illustration in my next slide. And finally, it is related to the existence of such relationship. If that is being confirmed by any person, such opinion by that person is a relevant fact. That is the first half of section 50. The second half of section 50 discusses about few exceptions under section 50. Now below are the provisions which will not be covered under section 50. The first one, if it is related to proving a marriage under the proceedings under the Indian Divorce Act 1869, then this opinion is not a relevant fact. Or if it is related to any of below IPC sections, that is IPC section 494 which discusses about bigamy, section 495 which discusses about bigamy with concealment of fact, section 497 which discusses about adultery, section 498 which discusses about enticing or taking away a married woman. Now if any statement or opinion made related to these sections, in that case such opinion will not be considered as relevant fact, or these are the exceptions to section 50. That is what you need to remember. With that, I am taking you through the illustrations that the act discusses about, and then I will also give one or two case laws. There are two beautiful illustrations available under section 50 and they are very simple and you should learn them because in competitive exams these illustrations will be asked. The first one is, the question in first illustration is whether A and B were married or not. Now what happened here? The friends of A and B usually receive them and treat them as husband and wife. Now this conduct of receiving and treating A and B as husband and wife has been witnessed by the family members or the friends or someone else. Now if they are going to court and making an opinion based on the conduct of friends, that is receiving and treating them as husband and wife, if they are telling that fact in front of the court, that will be considered as relevant fact. Now here A and B are considered as husband and wife, and that is how the friends always received and treated them as. So such fact is relevant when it comes to the court. Now the conduct of friends is receiving and treating, and if somebody is expressing the relationship between A and B based on such conduct, then the opinion given in front of the court is relevant. I hope you are understanding. The second illustration, the question here is whether A was the legitimate son of B or not. Now if the family members of B are treating A as the son of B, in such case the conduct by the family members of B is a sufficient fact, and if someone coming to court and makes an opinion based on the conduct of family members which is being witnessed, in that case such opinion is also a relevant fact. There is a case law which almost goes along with the second illustration, which is Bami Beva versus Krishna Chandra Swain, where the question was whether there was valid adoption or not, and here the statement made by cousin of adoptive father, the family priest and the family barber was considered as relevant because they have all witnessed several conduct by the family members, and it was held that the statement made by all these people are relevant. The second case law, that is Natba Paricha versus Nimai Charan Mishra, is also a landmark judgment. Here in this case law, the court says if a stranger comes to the court and says that A is the grandson of B, just because he has made an opinion, it is not directly admissible under section 50 unless it is supported by ample evidence of conduct. I repeat, unless it is supported by ample evidence of conduct. So any opinion will not be considered as relevant fact unless and until there is sufficient evidence to prove that there is such conduct. Only after proving that it will be considered under section 50. Saying so, the same case law says that the quantum of evidence. Now, how much should be the conduct available? It differs from case to case, and the court shall see the family and other circumstances and then decide how much of conduct to be considered. That can be differ from case to case, which is what held in this particular case law.